We'll straight away would like to start with today's episode, for which we have with us Mr. P.K. Malhotra. He's a former Secretary Law, Government of India. And frankly, who knows better about disputes and justice, but for him. We'd love to hear his thoughts and suggestions. So let us welcome Mr. Malhotra to the Global Resolve. Welcome, Mr. Malhotra. And with your permission, sir, I would straight away want to jump to a set of questions. And then as per your convenience, you can answer them. So what is mediation from your point of view? Do you think it is just a negotiation or something more than that?
Mr. Sanjeev, first of all, let me thank you for calling me on this platform, for sharing my thoughts on a very important topic of mediation, which is not important only from the Indian perspective, the Indian government point of view, but also personally, I have always been in favor of promoting mediation as compared to the normal litigation. And the reason is very simple. Pendency in the Indian courts is too large. It takes too long, more particularly when it comes to family disputes, contractual disputes. It takes years, and people doesn't want to spend years in resolving these disputes. So adjudication, resolution is very, very complicated, but in mediation, it is very simple and more effective for the simple reason that you maintain the party autonomy. You have the flexibility because you are not bound by the strict rules of evidence and CPC. Then it is in mediation, normally it is always you don't go strictly as per the provision of law, but you just to resolve the issue between the parties, of the dispute between the parties, you always think out of the box and you always try to arrive at an amicable settlement which will be acceptable to both the parties. Now, coming back to the question which you have raised, why mediation, what is the mediation and whether mediation is negotiation only? I think we have understood as student of law, we understand that when you are talking of negotiations, generally negotiations take place between the parties themselves and there is no third person. But when you're talking of mediation, because two parties are not on talking terms or they don't want to sit on the table, the mediator, who is a third independent person, it is he who brings to the parties on a table, and then in fact the process of negotiation between the parties starts. So in negotiation, it is the parties themselves who talk. But when you're talking of mediation, then a mediator, a third independent person, comes in between and bring both parties on a table so that they can talk to each other and arrive at an amicable resolution of the dispute between them or the differences between them. So that is how I differentiated between negotiation and mediation.
Perfect, sir. So frankly, I mean, in hindsight, I think it was the wrong question to someone like you because you know it, by heart. You've also given the inherent strength of mediation, the features and the highlighting the parts of mediation. So absolutely, on dot. So the follow-up question would be that if mediation is so good and it's a collaborative mechanism, then how come that most people are still inclined to settle their disputes through courts? Why do they not settle it through amicable ways? What's the driving force where they choose courts over a mediator or over a assisted negotiation, if I were to say this?
Mr. Sanjeev, why people go for litigation? Because there is no meeting of mind. There are differences. And when there are differences, most of the time they are not on the talking terms. Since they are not on the talking terms, and probably it is the ego problem between the parties that I am right, the other person is wrong, and therefore I will take him to the court of law and see that I get a favorable decision. Just to satisfy their ego, I think most of the time, and more particularly in many disputes, more particularly I made a reference to the family disputes, like custody of the child, divorce, judicial separation, this kind of disputes, or even in contractual matters where certain payments are to be released for giving strict interpretation to the provision of the contract, this type of dispute arises. But if the parties sit on the table and they negotiate, probably maybe they feel that there is a meeting of mind and probably fault is on both sides. If the fault is on both sides, then probably there is always a give and take. And if you adopt the policy of give and take, in that scenario, probably mediation becomes very, very important. And the role of the mediator becomes very, very important because he provides that kind of comfort to the party. So it is many a time the disputes go to the court because of the ego problem, and many a time our counsels, the advocates to whom the parties approach, that what is the way forward, how we should go. Many a time our counsels don't give them proper guidance and don't tell them how they should proceed. On the contrary, they always tell him, okay, you go to the court, I will see that you win the case, and he loses it. If this kind of assurance is given by the counsel, probably that the parties are persuaded to go to court instead of going for amicable settlement or in mediation. It is not necessary that invariably the mediation will succeed. Mediation may fail also. And historically, we have seen, talking in the Indian perspective, look at the Mahabharata. Why Mahabharata took place? Lord Krishna went to Yudhishthira and asked him that there is a possibility of settlement. Give the Pandavas only 5 villages. We will be happy with that. But at that time, he was said, not even sui ki nok ke barabar bhi aapko zameen nahi milegi. If that kind of approach is there, the mediation failed.
Yes.
But talking of the litigation itself, that is one kind of lawyer, but it is not always that way. Look at what Mahatma Gandhi has said in his autobiography. What he has said that during his practice of more than 2 decades, most of the time he always preferred and persuaded his clients to settle their disputes through mediation or conciliation. And he said in the process, he never lost money and he always maintained his conscience. That's a great quality. I mean, he never compromised with his integrity. He got the money as well as the disputes were settled. And looking at the recent past, I'm giving the recent example, even our own Supreme Court, in Ayodhya matter, in spite of the fact that the dispute was on since independence and even prior to independence also, suit was pending. And even the Supreme Court also at the apex stage and the final stages said that let us try for mediation, and probably whatever was discussed in the mediation probably persuaded the court to come to a decision and passed a judgment in that matter.
Agree. So, sir, there's a small follow-up question, and the reason why I asked that, why people are inclined to, go to the courts quickly. I mean, someone said, and it became a debate of its own kind, have our minds got conditioned that we do not want to own our own decision-making, and we are better off by letting it be decided by a third party, and then we say, okay, that's a fait accompli. So somewhere over the period, it's a kind of a trap that we go with our dispute to a third party says, you are right, he's wrong, you are happy, the other party is not, and that's the way the world has evolved. Do you think somewhere we've got conditioned and we don't want to even try it out differently?
I think, Mr. Sanjeev, you have raised a very valid question, and that is one of the bottleneck which we have to face. Because most of the time people, even when they sit on the table, mediate and then ultimately come to a conclusion. One of the parties who is losing it or the decision is not as per the negotiation on the table, he goes out and then he backs out. So its enforceability becomes a problem. The decision taken in mediation, it's enforceable because the mediator, who is an independent person, he is not deriving his authority from the law. Since he is not deriving his authority from the law, and a person going outside, one of the party going outside, backs out from mediation, probably its enforceability becomes a problem. Because there is no law regulating it. Of course, now the law is in the making. Of course, we will discuss about that law also, which is in the making. Right. But it is only because of that reason that in our law, in our country, there are 2 kinds of mediation. The kind of mediation which you are talking of, which is not backed by the law, there is a possibility that it will not be enforced. But in India, we have developed a concept of court-monitored mediation. And this court-monitored mediation derives its authority from Section 89 of CPC. Because Section 89 of CPC mandates every court that before it starts adjudicating a dispute, it should persuade the parties to go for alternate dispute resolution mechanism, which include arbitration, conciliation, mediation, lok adalat, or the Gram Nyayalas also, which is also a part of this, because in Gram Nyayalas also there is a separate legislation for that. Unfortunately, that has not been properly implemented the way it should have been. But the fact remains, these methods must be adopted. And to give effect to this, even at the district level, at High Court level, and even at the Supreme Court level, the courts have created mediation centers. There the mediation take place, and in case in the mediation the parties arrive at a conclusion, the decision arrived at in the mediation is placed before the court, and the court passes in accordance with the decision arrived at in the mediation process. So this kind of court monitored mediation has become successful, and depending on its success, now some of the legislations are also making provision for it. And these provisions take, for example, the Consumer Protection Act, and even the Commercial Courts Act. And the Arbitration Act itself also provides for conciliation. Of course, now that conciliation chapter is being removed, and we are going to get a new mediation law on that. But the fact remains, but that the time has come when we want to have an standalone legislation to give legal backing to mediation. Of course, there are questions relating to it, more particularly with regard to the bill which has been introduced in the parliament and which is pending in the parliament. Some questions are being raised because they say the kind of party autonomy you are looking for, that is going, and probably you are forcing the parties to go for a mandatory kind of mediation, which is not the fundamental principle of mediation, because mediation is voluntary. So there are many issues which are coming. But the fact remains, the time is ripe, keeping in view that we don't have a good judge population ratio. Pendency in the courts is too large. There are large number of vacancies of the judges. In the courts, it takes decades to get a dispute settled. Therefore, out-of-court settlement is very important. And since we have seen that even in arbitration, in spite of the best efforts, the disputes are not resolved in a timely manner, and they are very effective. Therefore, mediation is becoming a more effective and more sought-after way of settling or resolving the disputes. And I think it is becoming popular day by day.
Great. Right, sir. So, sir, again, out of the discussion we have had, there is a very important aspect which comes out. Do we normally look at justice, or the parties in dispute are looking at solutions? And does the justice always lead to a solution where both the parties actually kind of say that, okay, this is what we wanted? Otherwise, it will be a winner takes all, or who's right and who's wrong will be decided. So, any comment on that?
Yes, Mr. Sanjeev, I think this is another important question which you have raised. I think you are looking at the problem in two watertight compartments, that either it is a resolution or question of justice. So I'm talking of just resolution of the dispute between the parties. So when you go for mediation, in a mediation, just resolution in the best interest of both parties, it may not be a justice in the true sense of the word as it is legally understood. Because when you are talking of justice, the normal connotation in the mind of a law student will be justice means justice as per the strict provision of law. But once you are talking of mediation, in mediation, it is always give and take. Why it is give and take? Suppose there is a dispute and somebody owes me 1,000 rupees. I go to the court of law and file a suit for recovery of 1,000 rupees. I spend money on court fee. I spend money on paying to the lawyer. Then every date of hearing, I go and attend it in the court, and the dispute is resolved, say, after 10 years, and I get justice and I'm paid 1,000 rupees. But for recovery of those 1,000 rupees, maybe I have spent 800 rupees and 10 years of time. So my net gain is only 200 rupees. But in mediation, if today, instead of 1,000 rupees, we sit across the table and the mediator make us agree to say 500 rupees, am I not a gainer?
Both the parties.
So probably it is a just resolution of the dispute, that where you avoid litigation and it gets a binding force. Suppose I get a favorable decision from the court, the other party, because I'll be getting the 1,000 rupees, but the other party can again go and challenge it in the court of law. Again, there will be appeal and other expenses. So would you like to opt for that kind of justice, or would you like to go for just resolution of the dispute where you may not be getting a full compensation, but it is a reasonable compensation to avoid the legal hassles which you have to face in the Indian legal system?
Got it. Excellent, sir. So this was essentially a hybrid between solution and justice. There is something between called just resolution. So I think that was a great insight. Thank you. So second the next one would be, why mediation all this while has been a part of the legal profession? Could it not be a self-standing independent profession other than being, as making it as practice of law? Because it's more of a mindset issue. A mediator should be like, more of a process expert. He should be able to bridge the gap between the parties. So yes, great if he's a law student or with a legal background, but we of course can have engineers and doctors and anyone for that matter who understands the human psyche and who's willing to sit in between. So would you have a view on this?
Yeah, I think that is another very important question which you have raised, because even when I'm talking of court monitored mediation, this has again been monopolized by the legal profession. And people belonging to the legal profession generally act a mediator, though there is no legal bar that the other person cannot be a mediator. Let me tell you at the outset, a person who is not with a legal background, not having a law degree, can also be a equally good mediator or a better mediator than a person with a legal background, because a person with a legal background has a particular mindset, because every day he is appearing in the courts and he develops a kind of judicial mind. So what I'm saying, the point which I'm trying to differentiate is, as a mediator, you should have a judicious mind, not necessarily a judicial mind, because a judicial mind goes into the technicalities of the law, but a judicious mind looks for resolution of the dispute based on principles of natural justice. That, okay, this is how it should be done. And this court monitored mediation, which I talked about, which I have said that it is successfully working in the country, but it has a flip side also, because invariably all these mediation centers are working either in the district court or in the high court or in the Supreme Court. So a litigant or a person who wants his dispute to be resolved, he has to go in the same kind of environment, people with black coat sitting there, imposing their will or decision on the party. So probably the kind of comfort which he should get, he is not getting. So once you are talking of the mediator, I feel it should not be confined, or it should not remain a domain of the people from the legal profession. No doubt they are the best person to resolve it. I'm not questioning their competency, right, but I'm saying there are equally competent persons available outside the legal fraternity also who can be a better mediator. You see, what is the good quality of a mediator? The good quality of a mediator is he should not criticize the issue or point being discussed by both the parties. He should make both the parties comfortable to ensure that whatever decision they are going to take is in interest of both the parties. He should never lose his temper. He has to be a very cool-headed person. He must tell them the legal provision, but he says that it is not necessary that you have to confine it to legal provision. You can go beyond that. And beyond legal provision also, there are solutions available for your problem. So therefore, my point is very clear. And second point which I want to make is, not only that it is not confined to the legal profession, there can be good mediator outside the legal profession also. At the same time, if you are getting a new law on mediation, and you want mediation, not only court monitored mediation, but other mediation also to be successful under the new law which you are making, it is not necessary that you should have mediation centers in the court premises. I think they should be outside the court premises, and the person who is mediating should not sit with a black coat and a tie and all that. He should sit with the persons who want to resolve the dispute as a normal person, as if he is part of them and he is not sitting as a judge. That kind of comfort level should go to the person. Then I feel probably the resolution of disputes will be much more convenient as compared to what it is happening in the court monitored mediation. I know, even because I am myself working as a mediator, I'm also working as a conciliator, I'm also working as an arbitrator. There are different kind of traits which an arbitrator should have. There are different kind of traits which a conciliator should have. There are different kind of traits which a mediator should have. Whatever techniques you are adopting as a mediator may not succeed in the arbitration. Whatever techniques you are adopting in arbitration may not succeed in mediation, because you need a different kind of training for all these kind of things, and you must have a different kind of temperament for all these things. So I feel time has come when you should have independent mediation center. And I think the industry houses can do work in this. Even the professional can help us. And I think many mediation centers have also come into existence and they have started working. But unfortunately, because enforceability is a problem, so they are not yet successful. And it is only the court monitored mediation which is still prevalent in our country.
So, sir, in this answer, you've already kind of given your view on my next question, where I wanted to check with you. Do we feel, or as it's normally said, the lawyers have become the gatekeepers of justice? So, in a way, you actually, gave that answer, which is not true. Yes, they can be one good mediator. They know how to resolve. They have been part of, the judicial system. But even if you don't have the black coat with you, and even if you don't have the legal degree with you, you are still, with the adequate traits, you can still, be a good mediator. So absolutely. Sir, you made a reference to the current mediation bill, a couple of times. So what is your take on the bill as it stands? I understand we don't have the, what should I say, the reality as of now in terms of how much time would it take for the parliament to discuss and make the adequate changes. They've already got some feelers from the market, open consultations are there. We personally have given our suggestions. So right now it is being mulled over. But by the time it comes, what exactly your feel is, to the extent we've heard in the market or we've seen the draft bill?
You see, I have always been a votary of having a standalone legislation for mediation. And of course, the bill which has been introduced in the parliament, there was a committee which has given its report. That report was considered. Then it was the pre-legislative consultation process, which I always say should be followed, has also been followed. But in spite of that, the suggestions which were given to the government by various agencies, my report is that most of suggestions have been negated by the government and the bill has been introduced. And probably there is a feeling among the people who are concerned with this particular subject that the objective which you want to achieve by this mediation bill, there is a big question mark on that. Why? Because the law is providing, the which you are going to introduce, that any dispute going before the court must undergo through a process of mediation. If you are making this kind of provision, then in already pending cases, large number of pendency in the court, you are adding one more layer which must be completed by both the parties before they can go for adjudication through a normal process of litigation. And there are no timelines prescribed for that. So that I think can create a problem for us, because ultimately we say mediation. What is the concept of mediation? Concept of mediation is parties themselves decide that, okay, we want to mediate. But here by law, you are forcing them to mediate. So I think that is likely to create some problem. And the kind of party autonomy which we are talking of also get compromised, because this law is making provision for our Mediation Council of India, which will be regulating the whole concept of mediation and will be issuing guidelines, rules and regulations. So if you are going to have a list which will be approved by the Mediation Council of India and only those people can mediate, then probably again the kind of party autonomy with regard to selection of the mediator and the dispute which they want to take to the mediation, I think will also get compromised. But once you bring a change, I think these are the problems which are likely to come. Maybe we should give a thought or a clearance to this particular bill. Let the bill be passed by the parliament, and once its implementation starts, whatever problems come, probably those problems at that time we can look for alternate solutions. And if there are better methods or mechanism available, the law can always be amended at a later stage. We have seen this kind of precedent even in the insolvency and bankruptcy code also. In 2016, the law was passed. Then whenever there is a problem during the last 5 years, the law has been amended 6 times by the parliament. So similarly, let us give a clearance to this particular, let it be implemented, and during the course of implementation, in case certain difficulties are coming, then obviously the parliament has got authority to amend that law. And the objective of having a standalone legislation for successful implementation of the mediation in our country will be implemented. And I think people will be more comfortable in settling their dispute through the process of mediation, because it is a win-win situation for them. It is less time consuming, it is less expensive, party autonomy is maintained, confidentiality is maintained. And I think then, as I said, timelines are very important, and both parties feel that they have succeeded in the matter, and the decision arrived at in the mediation get finality, because there will be no further appeal against that.
Got it. So, sir, nobody better than me in a way to vouch for the amendments which we had in IBC. We've seen the law actually, turning on its head. So, from that perspective, it also speaks very highly in the government that the moment they have figured out that there were inconsistencies or anomalies or the need of the hour was a change, they have been pretty quick, agile in making amendments and tweaks. So that was really appreciable. And yes, but to the extent we can still have the best of the drafts getting approved, even in case of mediation bill, I think the lesser would be the need of the amendments, because it does take its own time and effort. But so a couple of last questions I have. One is, we've been talking, India has been saying, for a while that India should have been the hub for international arbitration. And somehow something kind of, didn't add up, and it always, remained a dream. Do you think that we have now a golden chance to actually acquire, the crown for the hub for international mediation, at least? Because it is in part of, I would say it's ingrained in our culture. We are a pretty tolerant, I would say, a society, or a race as a country. We have seen it comes naturally to us. Do you think we can actually, grab this opportunity and say, come to us, we have the best of the mediators and we know how it, what it takes to mediate?
Mr. Sanjeev, I have to be a little blunt in answering this question.
Please do, sir.
You see, we have been talking of making India as hub for international arbitration.
Right.
This talk has been going on for more than 2 decades.
Agreed.
We have created that kind of legal framework in our country by amending our arbitration law in 2000. Our 1996 law of arbitration is based on ancestral model law.
Right.
In spite of that, we thought probably if we want to make India as hub for international arbitration, probably we need to update our law, which was done in 2015. Again, in 2019, major amendments were made in this legislation. But in spite of that, we have not been able to create the infrastructure inviting people to use India as a platform for international arbitration. On the contrary, most of the Indian parties are also going for arbitration either to Singapore or to London or or Paris, or maybe now even other places in the Gulf, which I think is not a healthy development. Why? It's not that you don't have a legal talent. You have the legal talent. It's not that you don't have enough advocates available. You have enough advocates available, because our own advocates are going and arguing the matters in London, in Paris, in Singapore, and in Hong Kong. So there is no problem. Only thing is kind of infrastructure which is needed, we have not created. And the kind of delay which you take in our judicial process, I think that's a great fear at the back of the mind of those people who don't opt India as a center for arbitration. So my only concern is you have the legal framework, but the kind of changes the kind of mindset which is needed, and the delays which are taking place in the court, and secondly, the infrastructure which you were supposed to create has not been created. If you create that kind of infrastructure, and the delays in the court can be taken care of, in spite of the fact that we have created a commercial court for settlement of all these disputes or for hearing of these appeals, and timelines are given, but those timelines are also not being adhered to. If we are able to implement this kind of legislation properly, I don't see any reason why India cannot be made as a hub for international arbitration. And the same principle apply to mediation also. We can do that, provided we create that kind of infrastructure in our country, and we provide that kind of facility, and then the kind of intervention which takes place in the court and the delay which takes place, that delay, if that can be avoided, there is no reason why can't we make India as hub for international mediation.
Great, sir. So a small issue which you raised, which is very pertinent even for mediation, where the government pushed the institutional arbitration all this while, and we suffered because of lack of infrastructure. And it so happens that in the country currently, I think 98% of arbitration is ad hoc. Now, same thing we are trying to push through in mediation, I mean, through the bill, where there is a lot of focus and voice with regards to institutional mediation, where we still would probably falter if we ignore the private mediation bill. So let both both the options flourish. Let people, and by the time the government is in a position to add infrastructure as is required, at least let private mediation not be called ad hoc mediation. It should be taken in the same way, because at the end you are getting your purpose resolved, by letting people on their own understand and all. So I would definitely agree with this. So the last question, what would be your message to the mediators or wannabe mediators? Because there's a lot of talk. People are at times confused, because I have spoken to beneficiaries, potential beneficiaries in parties in dispute. They say we don't get, the skilled mediators. We don't get people who we can trust. I speak to mediators. They say we don't have parties who come to us. We are ready to do that. What is the gap? Why it's happening? What else can be done? The missing bridge needs to be there somewhere, no?
Yeah, I think that is another very, very important question, Mr. Sanjeev, which we have raised. You see the kind of confidence which, unless the parties have a confidence on the mediator, probably they will not be going to the mediator. That goes without saying.
Agreed.
So in case of institutional mediation and ad hoc mediation or private mediation, as you are calling it,
right,
I think the system which is prevalent today, so far as the arbitration is concerned, in spite of the fact that we have institutions which is conducting arbitration, and the institutions have their own rules, right, and parties are aware, right, that if they go to the institution, these kind of arbitrators will be available. This is the amount of fee which they will have to pay. Then there are timeline within which the dispute will be sorted out. But still, majority of the people go for ad hoc arbitration. And one of the reasons, again, which we said initially, is the mindset of the parties. You see, under the law, what happens? Every party appoints its own arbitrator. Two parties, both appoint their own. And probably they have a mindset that if we have appointed an arbitrator, he will be taking overstand in the arbitration proceedings. I think that mindset need to be changed, because once a party appoints an arbitrator, he acts independently as per law, and he takes a decision based on the facts and the legal position which emerges in front of him. So that mindset, unless that changes of the parties, and they still feel because we have appointed a mediator, he will take a side on my side. So probably that kind of, then probably it will be a difficult proposition. So a message should clearly go that a mediator is an independent person. And as I said, he has to behave not like a judge. He has to behave as a friend of the parties in dispute. If he is acting as a friend of the parties in dispute, probably he will be generating more confidence. And if he is dealing with a situation, he has to be firm in his responses to the issues which are raised by the parties before them. Unless he does that, the kind of confidence which parties will want to create will not have. Therefore, under the law which is being made, the government has proposed this Mediation Council of India. The job of the Mediation Council of India will be to empanel mediators who have a good track record, who are knowledgeable. And idea is to instill a confidence. If you are referring a matter to one of the mediator who is empaneled by the Mediation Council of India, he will be independent and impartial. And as I said, sitting on the table, he has to behave like a friend and not as a judge. And therefore, this black coat culture in any case has to go. And even if he is a retired judge, even if he is an advocate, when he's sitting for mediation, he should sit like a normal person, not as an advocate or as a retired judge.
Got it, sir. Great, sir. So that was lovely talking to you and having your insights on this thing. And, when it comes from people like you, right from heart, so when people will have a look at, these conversations, they'll really appreciate and understand. So it really, there's a lot of effort required in awareness and sensitization of the stakeholders. And our initiative is just to help the parties to understand better what is mediation and why they should be making it as a first port of call. So, that was lovely, and I would really want to thank you, from the bottom of the heart in terms of taking out time and, sharing your views with us. Any comments you have for that?
Thank you, Mr. Sanjeev, for providing me this platform to share my thoughts and giving this opportunity to respond to some of the questions which you have raised. Going by the present scenario, which is prevalent in our country with regard to the litigation, be it civil disputes, be it criminal matters, be it contractual matters, in spite of the fact that we have created a legal framework because of lack of infrastructure in the courts, because of shortage of judges, and because of large pendency in the courts, disputes take long time to settle. So probably my advice to all the litigants will be, your first option should always be alternate dispute resolution. It is only when you feel that, well, there is no possibility of settling a dispute by using ADR mechanism, only then you should go for litigation. Otherwise, litigation at any cost should be avoided. People feel that probably people in the legal profession will be adversely affected by this kind of advice. But my personal experience is it will never be so, because then the trend of practice will change. Take, for example, with the use of computer, with use of artificial intelligence, only this way of practice has changed. It is not that the professional activity has gone down. Professional activities continues, only the mechanism or methodology has changed. So similarly, my advice is that litigation should be the last option and ADR mechanism should be the first option to be explored by all the litigation, more particularly in our scenario where we don't have enough judges to decide all disputes and the pendency in the courts is too large. And even if you are not getting full justice, even if it is a resolution of the dispute, just resolution of the dispute, please accept it, because in the larger interest or in the long run, that is in the best interest of the individuals, because you buy a peace of mind, you don't spend money on that, and your energy and your intellect can be used for other better activities in the life.
Got it, sir. Can't agree more. Absolutely. So lovely, sir. So thanks a lot for the time again, once again, and definitely we'll come back to you as we move forward with a new set of questions on mediation.
Thank you, Sanjeev.
Thank you, sir.
Thank you very much.
Thank you.
Thank you.